Illegal immigration in the United States, with an estimated 50 to 60 million undocumented immigrants, including 20 to 30 million present before 2020 and over 20 million entering since, poses a significant challenge, intensified by the conflict between constitutional protections and the demand for rapid enforcement. The application of due process and anti-discrimination laws to undocumented immigrants, rooted in the 5th and 14th Amendments, complicates efforts to achieve swift deportation. This article examines various legal mechanisms proposed to address illegal immigration, such as redefining invasion, declaring war, invoking national or state emergencies, and expanding expedited removal. It assesses their feasibility and identifies citizen-led enforcement as the most effective strategy for removing undocumented immigrants within current legal frameworks. The central theme is navigating constitutional and statutory constraints while pursuing practical, immediate solutions to reduce the presence of undocumented immigrants in local communities. Legal framework and due process protections. The 5th and 14th Amendments guarantee due process to all persons on United States soil, encompassing citizens, legal residents, and the estimated 50 to 60 million undocumented immigrants. This constitutional mandate, affirmed in landmark Supreme Court decisions such as Yiqua v. Hopkins in 1886, Zedvitas v. Davis in 2001, and Boumediene v. Bush in 2008, ensures that no individual is deprived of life, liberty, or property without fair legal procedures, typically involving notice and a hearing. In the context of immigration, the Immigration and Nationality Act requires removal proceedings for deportation, mandating a notice to appear and a hearing before an immigration judge. This process applies universally, with approximately 90% of cases resulting in deportation, though a backlog of 2.8 million cases contributes to delays of 1 to 3 years. Due process extends to all classifications including criminal aliens, undocumented immigrants with convictions, who face both criminal trials and immigration hearings, and enemy combatants, who receive military tribunals or habeas corpus reviews. Only 5% of undocumented immigrants have serious convictions, limiting the criminal alien designation's scope. Enemy combatant status, reserved for those engaged in hostilities like terrorism, is inapplicable to most undocumented immigrants, as less than 0.01% are linked to such activities. Expedited removal, authorized under federal law for undocumented immigrants apprehended within 100 miles of the border and within 14 days of entry, represents the least procedural mechanism, involving officer verification and asylum screenings. Even this process, upheld in Department of Homeland Security v. Thuraissigium in 2020, constitutes a form of due process, ensuring no status entirely eliminates legal protections. Anti-discrimination laws, including the Civil Rights Act of 1964 and 42 United States Code Section 1981, further complicate enforcement by prohibiting actions targeting individuals based on race or national origin, as seen in Plyler v. Doe in 1982, which extended equal protection to undocumented children. These legal frameworks, while ensuring fairness, create significant hurdles for addressing the scale of illegal immigration, estimated at 50 to 60 million. Historical context and the 14th Amendment. The 14th Amendment, ratified in 1868, was primarily designed to secure citizenship and equal protection for freed slaves following the Civil War, addressing systemic discrimination through its citizenship and due process clauses. The amendment's broad language defining protections for all persons was not intended to address immigration, which was minimal in the 1860s with no federal illegal entry law until 1875. Immigration at the time was approximately 100,000 per year, a stark contrast to the modern influx of over 20 million since 2020, contributing to the total of 50 to 60 million undocumented immigrants. Judicial precedents, beginning with Yiqua v. Hopkins, extended these protections to non-citizens, applying them to contemporary immigration contexts unforeseen by the framers. The Citizenship Clause, affirmed in United States v. Wong Kim Ark in 1898, established birthright citizenship, while due process and equal protection clauses were interpreted to cover all individuals, including undocumented immigrants, as seen in Zedvitas v. Davis and Plyler v. Doe. Historical deportation efforts, such as Operation Wetback in 1954, which removed 300,000 individuals with minimal process, succeeded due to lax constitutional standards. However, contemporary courts enforce stricter due process, rendering such approaches obsolete. The extension of 14th Amendment protections to undocumented immigrants is an unintended consequence of its universal language, not a deliberate scheme to shield illegal immigration. Orchestrated efforts by judges, prosecutors, and lawmakers to protect the 50 to 60 million undocumented immigrants contribute significantly to delays in immigration enforcement, constituting a coordinated barrier to rapid deportation. However, other factors exacerbate this issue, including severe underfunding with only 600 immigration judges handling a backlog of 2.8 million cases, and sanctuary policies in over 600 jurisdictions that limit immigration and customs enforcement cooperation. The sheer volume of illegal aliens, with 20 to 30 million present before 2020 and over 20 million entering since, overwhelms the judicial system, highlighting the urgent need to address enforcement within these legal and logistical constraints. Proposed mechanisms to circumvent due process. The challenge of addressing an estimated 50 to 60 million undocumented immigrants in the United States has prompted exploration of mechanisms to bypass due process, aiming for rapid deportation within a legal system anchored by the 5th and 14th Amendments. Proposals such as redefining invasion, declaring war, invoking national or state emergencies, and expanding expedited removal seek to overcome constitutional protections that mandate fair hearings for all persons. Each mechanism, however, faces significant legal, practical, and political barriers, rooted in judicial precedent, resource limitations, and public opinion. The following analysis evaluates these approaches, highlighting their constraints in achieving swift enforcement against the backdrop of a complex immigration landscape. A redefining invasion. Article 4, Section 4 obligates the federal government to protect states against invasion, historically interpreted as armed state-sponsored attacks, as in the prize cases in 1863. Proposals to redefine invasion to include illegal immigration, citing 1.5 million border apprehensions and 700,000 gotaways in 2023, argue that undocumented immigrants constitute a non-armed invasion potentially facilitated by United States policies, such as sanctuary cities or foreign governments. Courts, as in Padilla v. Bush in 2002, reject this, requiring evidence of organized hostility, which is absent despite the scale of 50 to 60 million. Redefining invasion via congressional law or presidential order faces judicial scrutiny and does not eliminate due process, as hearings remain mandatory under Zedvitas v. Davis. The potential for undocumented immigrants to acquire weapons, with 300 million firearms in the United States, does not meet invasion criteria, as less than 5% have serious convictions and no widespread arming is documented. A declaring war. Declaring war on undocumented immigrants was considered but deemed legally impossible, as civilians are not enemies under constitutional or international law, including the Geneva Conventions. Such a declaration would violate due process protections as affirmed in Boumediene v. Bush, and face immediate court injunctions. The Posse Comitatus Act prohibits military involvement in domestic enforcement without congressional authorization, and scaling military action to address 50 to 60 million would be logistically unfeasible. A national emergency. A president can declare a national emergency under the National Emergencies Act, as seen in 2019 for border wall funding, redirecting $6 billion. This mobilizes resources but does not bypass due process, with deportations requiring hearings or expedited removals limited process. Judicial limits, as in Sierra Club v. Trump in 2019, and congressional oversight restrict effectiveness. Immigration and Customs Enforcement's $8 billion budget and 20,000 agents deported 186,000 in 2023, insufficient for 50 to 60 million, estimated to cost $315 billion. Or expanding expedited removal. Extending expedited removal nationwide, removing the 100-mile and 14-day limits, was proposed to minimize due process. The Department of Homeland Security's 2019 attempt was blocked in Make the Road New York v. Wolf in 2020 for violating due process and administrative procedures. Even if implemented, expedited removal retains screenings, and scaling to 50 to 60 million requires infrastructure far beyond current capacity, with a single 2008 raid of 389 individuals overwhelming systems. State emergencies or invasions. Governors can declare state emergencies, as Texas did in 2021 with Operation Lone Star, mobilizing National Guard and state police with a $250 million budget. However, federal preemption, established in Arizona versus United States in 2012, restricts states to supporting roles, not deportations. Texas' 2022 invasion declaration was symbolic, with courts rejecting immigration as invasion in Padilla versus Bush. State actions like Texas Senate Bill 4 in 2023 were blocked for usurping federal authority, limiting governors' impact on the 50 to 60 million undocumented immigrants. These mechanisms falter against constitutional protections, judicial oversight, resource constraints, and political divisions, with 60% of Americans supporting some legal status. The legal system's reliance on precedent locks in due process, rendering systemic changes such as amending the 14th Amendment unfeasible due to the need for 2/3 congressional approval and 38 state ratifications. Addressing the scale of 50 to 60 million undocumented immigrants requires strategies within current legal frameworks, as these proposals cannot bypass the entrenched constitutional and statutory barriers. Citizen-led enforcement as the optimal strategy. Given the legal and practical barriers to bypassing due process, citizen-led enforcement emerges as the most effective strategy for removing undocumented immigrants from local communities amidst the estimated 50 to 60 million nationwide. This approach leverages existing federal and local mechanisms to accelerate deportations and deter settlement within constitutional constraints, achieving results in weeks to months. Key actions include reporting to Immigration and Customs Enforcement. Citizens can contact Immigration and Customs Enforcement at 1-866-DSU ICE or online at ice.gov/Tiplani, providing specific evidence such as names, workplaces, or addresses. In 2023, Immigration and Customs Enforcement deported 186,000 individuals, including 56,000 non-criminals, with tips triggering raids in weeks, as seen in Texas where a single tip led to 20 deportations in a month. Anonymous reporting ensures compliance with anti-discrimination laws and avoids harassment charges, using terms like illegal alien to align with federal law. Lobbying for 287G agreements. Advocating for local sheriffs to join the 287G program enables police to detain undocumented immigrants for Immigration and Customs Enforcement, with 150 jurisdictions detaining 70,000 in 2022. Georgia's 2020 citizen lobbying expanded 287G, increasing deportations by 30%. Public demands at sheriff or council meetings, using neutral language to comply with Arizona versus United States, can secure adoption within months, countering sanctuary policies in over 600 jurisdictions. Petitioning for E-Verify mandates. Local ordinances requiring E-Verify for employers deter undocumented hiring, reducing economic incentives for the 50% of undocumented immigrants in low-wage jobs. A 2023 Midwest campaign cut undocumented jobs by 20% in 6 months. Petitions supported by 100 to 500 signatures and drafted with legal guidance to avoid discrimination violations, force council votes in months, as in Farmers Branch, Texas in 2006. Supporting enforcement candidates. Voting for or volunteering with sheriff and council candidates who prioritize 287G or E-Verify shifts local enforcement. In Florida, a 2020 sheriff election led to increased detentions, with campaigns on platforms like X amplifying support. This action, protected as free speech, delivers immediate policy changes post-election, targeting local segments of the 50 to 60 million undocumented population. Pressuring federal lawmakers. Contacting congresspersons and senators at 202-224-3121 to support bills like House Resolution 2, which passed the House in 2023, boosts Immigration and Customs Enforcement funding for non-criminal deportations. Coordinated campaigns with organizations like the Federation for American Immigration Reform enhance impact, influencing long-term enforcement capacity to address the scale of 50 to 60 million. Monitoring and scaling efforts. Tracking outcomes through local news, X, or Immigration and Customs Enforcement's 287G list ensures sustained pressure. expanding via community groups or X campaigns, as in 2023 Midwest raids, amplifies deportations and DEETR settlement. Adjusting strategies, refining tips, targeting new officials, or escalating to state lawmakers, maximizes impact, addressing local undocumented populations effectively within the broader context of 50 to 60 million. This strategy succeeds by operating within legal boundaries, avoiding court injunctions, discrimination lawsuits, and federal preemption challenges. It directly addresses local undocumented populations, unlike border-focused emergencies or symbolic invasion declarations, and leverages Immigration and Customs Enforcement's existing capacity, which achieved 186,000 deportations in 2023. The combination of immediate actions, tips, medium-term policy shifts, 287G, E-Verify, and long-term advocacy, lawmaker pressure, maximizes impact, tackling the significant challenge posed by the estimated 50 to 60 million undocumented immigrants with precision and speed. Confronting the scale of illegal immigration, legal strategies and historical alternatives. Addressing illegal immigration in the United States, with an estimated 50 to 60 million undocumented immigrants, including 20 to 30 million present before 2020 and over 20 million entering since, demands navigating a complex legal landscape anchored in the 5th and 14th Amendments. These constitutional protections, extended through judicial precedents like Yickwa v. Hopkins, Zydvitas v. Davis, and Boumediene v. Bush, ensure due process for all persons, creating significant barriers to rapid deportation. The 14th Amendment's universal language, originally intended to secure rights for freed slaves, has been applied to undocumented immigrants, an unintended consequence exacerbated by modern immigration dynamics absent in the 1860s. Proposals to redefine invasion, declare war, invoke national or state emergencies, or expand expedited removal falter against constitutional mandates, judicial oversight, resource limitations, and political realities, with 60% of Americans supporting some form of legal status for undocumented immigrants. The sheer scale of the challenge, 50 to 60 million undocumented immigrants, underscores the urgency of effective strategies within current legal frameworks. Citizen-led enforcement, encompassing reporting to Immigration and Customs Enforcement, lobbying for 287G agreements, petitioning for E-Verify mandates, supporting enforcement candidates, pressuring federal lawmakers, and monitoring outcomes, offers the most viable path forward. These actions achieve tangible results within weeks to months, as evidenced by 2023 Immigration and Customs Enforcement raids in Texas and Midwest campaigns that reduced undocumented hiring by 20%. By leveraging Immigration and Customs Enforcement's capacity, which deported 186,000 in 2023, and local mechanisms like 287G, which detained 70,000 in 2022, citizens can directly target local undocumented populations without awaiting systemic legal changes, such as amending the Constitution, which is nearly impossible given the requirement of 2/3 congressional approval and 38 state ratifications. This strategy's strength lies in its compliance with due process, federal preemption, and anti-discrimination laws, avoiding the injunctions that have blocked broader proposals like nationwide expedited removal or state-led deportations. However, the strategies outlined here operate within the constraints of current legal and political realities, which prioritize constitutional protections and judicial oversight. Should these citizen-led efforts prove insufficient to address the scale of 50 to 60 million undocumented immigrants, alternative methods historically employed to remove unwanted groups from countries may warrant consideration. Historically, nations have used extralegal or coercive measures to achieve mass removals, often bypassing established legal frameworks. For instance, during the 1930s, Mexico's repatriation campaigns forcibly removed hundreds of thousands of Mexican nationals and Mexican-American citizens from the United States, often without due process, through coordinated sweeps and economic pressures. Similarly, post-World War II population transfers in Europe, such as the expulsion of ethnic Germans from Poland and Czechoslovakia, involved state-sanctioned forced migrations, displacing millions with minimal legal recourse. These measures, while effective in achieving rapid removals, operated outside constitutional norms and often violated human rights principles, leading to significant social and ethical consequences. Other historical examples include vigilante actions, such as 19th-century nativist movements in the United States that pressured immigrant groups to leave through community boycotts and localized intimidation, though these risked legal repercussions and social unrest. In extreme cases, countries have employed denationalization or mass internment, as seen in the internment of Japanese Americans during World War II, later deemed unconstitutional in Korematsu v. United States, overturned in 2018. Such methods, while historically effective in removing targeted groups, are incompatible with current United States legal standards, which mandate due process and equal protection, and would face immediate judicial and societal opposition. Their inclusion here reflects the possibility that persistent ineffectiveness of legal strategies may prompt exploration of these historical precedents, necessitating a re-evaluation of legal and ethical boundaries to address the unprecedented scale of illegal immigration. Conclusion: the citizen-led enforcement strategy remains the most practical and legally sound approach for now, empowering communities to act within the law while respecting constitutional mandates. By combining immediate actions like immigration and customs enforcement tips with medium-term policy shifts like 287G and E-Verify, citizens can reduce the local presence of undocumented immigrants efficiently. Yet, the magnitude of 50 to 60 million undocumented immigrants suggests that if these efforts falter, policymakers and communities may need to contemplate historical methods, adapting them to modern contexts while grappling with their legal and moral implications. The path forward requires balancing enforcement goals with the principles that define the United States legal system, ensuring that solutions remain effective, equitable, and sustainable in addressing one of the nation's most pressing challenges.